Hi, my name is Lindsay Bryce. I am a staff attorney at Standpoint, and I'm really excited to be here with you today. This is actually the first webinar that I am doing for Standpoint. We've done a number of other webinars over the last year. My other colleagues have done a whole series of different webinars, but this one's my first. So I'm really excited to be here. We're going to be talking about criminal law, and we're going to be talking about criminal law from the perspective of a misdemeanor domestic assault. Criminal law can be pretty complicated, and it's a very broad topic. So I wanted to start with one of the kinds of offenses that everybody sees on a regular basis, since this is for advocates. Ty, do you want to go through some of the housekeeping that we talked about?
Sure, yep. So hi, my name is Ty. I'm the Advocacy Support Program Manager, and I'll be moderating this webinar along for Lindsay. Just some quick housekeeping things. There is a question tab on that screen that you have. So if you do have any questions throughout the webinar, go ahead and type them in. And what Lindsay will do is after every topic, she'll answer any questions, and so I will give her the questions and then she'll answer them. For those questions though that are going to take too long to respond to, what I will do is I'll give those to Lindsay at the end, and then I'll have her respond via email or something like that. Or not only questions that are going to take too long to respond to, but questions that are more like case relevant, like if it's a specific case that you're working on or something like that, we'll follow up with you on that. And then also to let you all know, this webinar is being recorded, and basically that's all the housekeeping that I have, but I do have 3 poll questions that I want to ask, and what I'll do is I'll launch each of the questions, I'll ask the questions, and then I'll give you like 1 or 2 seconds to answer them, and then I'll give the results to Lindsay. And the reason for these polls are it allows Lindsay to know the audience that she's presenting to and things like that. So in case there's some things that she needs to special kind of like narrow down in. So the first poll question, I'm going to launch that, is how long have you been an advocate? So just select one, and when I see that everybody's answered, then I will close it and give the result to Lindsay. Okay. I think everybody's answered. I'm going to go ahead and close it. And the result then, Lindsay, is 30% have been in their position for less than a year, 26% 1 to 3 years, 22% 3 to 5 years, and 22% 5+ years. So we actually have all across the board for our audience today. The second poll question.
Group in terms of that poll question.
I'm sorry, what was that, Lindsay?
We have a really balanced group in terms of newer versus more experienced advocates.
Yeah, so you're just gonna have to just kind of, yeah. Okay, so the second poll question is, how many advocates are in your office? Are you alone there, or do you have less than 5, or 5 to 10, or more than 10? When I see the numbers stop, then I'll stop collecting them. Okay, I'm going to go ahead and close the poll now. And the responses were 19% just me, 46% less than 5, 15% 5 to 10, and 19% more than 10 advocates in the office there. So
great.
And the third poll question is, do you accompany victims to criminal court? Yes or no? And I'm going to go ahead and close it. And 93% of you do attend criminal court and 70% do not. So those are the results of the poll questions. Hopefully that helps Lindsay out a little bit in her presentation. And that's all that I had.
Great. Thanks so much, Ty. I really appreciate that. And like Ty said, if anybody has questions throughout the presentation, feel free to use the questions box to send those, and Ty will basically sort through them and get them to me at various times during the presentation or after the presentation. I'm also always available via phone or email. And I'll talk a little bit about Standpoint, but that's really one of the things that we do is we are here for you just about any time via phone or email in order to answer your legal questions. And I'll start there. I think I know that most of you probably know about Standpoint, but if in case we've got a few people on who have never heard of us, who were new to maybe new to Minnesota, I'll talk a little bit about what Standpoint does. Standpoint used to be the Battered Women's Legal Advocacy Project, so you may know us under that name. We're the same organization. We just went through a name change and a rebranding about 1.5 years ago. And one of the reasons that we did that is because, well, obviously we wanted to do some sort of an update to the name, but we also have always done work around sexual assault as well as domestic violence, and we understand that sexual assault is a component of domestic violence. So we wanted to make sure that our name reflected that also. So Standpoint is a statewide organization. We're a nonprofit, and we serve every county in Minnesota. We only serve Minnesota, and we are lawyers and advocates who work with victims of domestic and sexual violence, their advocates, their attorneys, and all of the other professionals who are working with them across the state of Minnesota. We strive to provide the same services in, say, Thief River Falls as we do in St. Paul or Minneapolis. And when I say you can call us anytime, I really mean that. We are here to take your calls, to take your questions. We're here to take your prosecutors' calls and questions. We love working with other folks in the system and doing what we can to help them do their job more effectively. So let's get started. Our objectives today are, they feel very basic, but when I started putting this presentation together, it felt like it got incredibly expansive and sort of difficult to organize. So hopefully it's organized in a way that makes sense to you. Our learning objectives, I want you to walk away with a better understanding of what misdemeanor domestic assault is, what that specific statutory crime in Minnesota is, what the particular criminal court process that goes along with the misdemeanor domestic assault looks like, and how you as an advocate can make that process, hopefully make that process a little bit easier on the victim involved in that case. You'll notice that I've got under advocacy tips, I have that in a pink circle, and you're going to see that throughout the presentation. What I tried to do was put sort of more factual information on the slide, and then the tips that are really specific to things that you can do as an advocate to make that process go more smoothly. Those will all be in the pink circles, or mostly will be in the pink circles. Okay, so this is specifically about misdemeanor domestic assault. However, I just did want to start by noting that there's a variety of other misdemeanors that you may encounter when you're working with victims of misdemeanor domestic assault. There are violations of orders for protection, and actually, before I start with that, I want to say a couple other things that broadly go throughout my presentation. Because of what we know about the statistics of who generally is committing domestic violence, I am generally going to use he when I'm talking about a defendant, an abuser, or perpetrator. And I am generally going to use she when I'm speaking about a victim throughout, just to make this a little bit easier and more understandable. But I do want to note that A, that isn't the only permutation, and B, there are also a substantial number of same-sex domestic assaults that occur, and we'll talk about that actually in just a few minutes. And I understand that my language is not encompassing all of the domestic assaults that you may encounter. The other thing that I just realized that when I went through my presentation a few minutes ago is that I use the acronym LE throughout without even thinking about it. And what that is law enforcement. So you will see LE all the way through here, and that's just my shorthand for saying law enforcement. Now, I'm sure there are other things that are either acronyms or they are words that I use because I live and breathe this stuff that I don't even realize I need to be defining. So when we come across things like that, please shoot a question to Ty. Let her know that I need to explain a particular word or an acronym, and I'm happy to do that. So to start with, some of the other misdemeanors that you may encounter when you're working with victims of domestic violence who are involved in a misdemeanor domestic assault case are violation of an order for protection, and the common acronym you'll see there is OFP, violation of a harassment restraining order, again the common acronym, violation of a domestic abuse no contact order, or a DANCO. DANCOs only are associated with an underlying criminal case. They aren't a separate order that you are going to apply for. And we'll talk about that a little bit later, but they can be the basis for a new misdemeanor charge. All of those misdemeanors, as well as misdemeanor domestic violence, get more serious the more of them you have. They're part of a group of crimes that a second offense within that family of crimes is more serious than a first, and a third is yet even more serious than that. You'll also often come across disorderly conduct charges. Again, that's a misdemeanor. It's often charged with a domestic assault. The county that I worked in, that I prosecuted in for a number of years, the vast majority of the misdemeanor domestic assault cases that we prosecuted were charged on the initial ticket by law enforcement as a domestic assault and a disorderly conduct. So there were multiple charges. Sometimes it was 2 counts, sometimes it was 3 counts, and again we'll talk about that later. 5th degree assault. Sometimes you'll talk to a victim and you'll be having a conversation and they'll be telling you about their case, and you'll realize that this is a person that they have a family or household relationship with, but it was charged as a 5th degree assault. And that happens when we hope that doesn't happen too often, but that happens when law enforcement and or the prosecutor has no idea that there's a family or household relationship that would make it a domestic assault. So you may come across those if they are charged that way and you think there's an inaccuracy in the charging, definitely reach out to your prosecutor. You may come across trespassing, tickets, that's another misdemeanor, or a theft. Those are some of the other kinds of cases you may encounter. But we're here to talk about misdemeanor domestic assault. And our statute is Minnesota Statute 609-2242, and there are 2 subdivisions. So there's 2 ways to commit domestic assault in Minnesota. And I have statute numbers on a lot of my slides, and I want you to know that those are all those statutes are available online. In fact, there's a slide at the very end that's going to give you the link to this particular statute, some of the criminal rules that we're going to talk about, and some other things also. But a lot of this information, the entirety of it, is available online. So for misdemeanor domestic assault in Minnesota, whoever does one of the following against a family or household member. 1, they commit an act with intent to cause fear in another of immediate bodily harm or death. So that's the first option. Or they intentionally inflict or attempt to inflict bodily harm upon another. And the shorthand and the way that prosecutors tend to talk about this is a domestic assault fear or a domestic assault harm. Obviously, the first one, committing an attack with intent to cause fear of another immediate bodily harm, that's the fear, and then the other is the harm. So a person can be charged with only a domestic assault fear, only a domestic assault, harm, or both, depending on the situation. And again, a really common charge will be domestic assault, fear, harm, or both, and a disorderly conduct as a second or third count. That's a really common way for law enforcement to cite someone. Now, I've highlighted a couple of the phrases here because those are phrases that are defined elsewhere in Minnesota statute, and they're really important, especially this first one is really important for you to know. Family or household member. This is a very broad definition to be used for domestic assault. So a family or household member is spouses or former spouses, parents and children, people related by blood, people who are presently residing together or who have resided together in the past, persons who have a child in common regardless of whether they have been married or have lived together at any time, a man and a woman if the woman is pregnant and the man is alleged to be the father, regardless of their living arrangements, or persons involved in a significant romantic or sexual relationship. Now, in order to, and I'm going to go back a second, in order to qualify as a misdemeanor domestic assault, it has to be committed against a person who fits into that definition of family or household member. So this definition really collects a lot of the people that we expect it to collect. It collects the boyfriends and the girlfriends and the husbands and the wives and the exes and all of those people. It also collects some people that we don't always think of as domestic violence. Parents and children. I handled a case that was charged as a domestic assault because it fit under the statute, and it was an adult. It was of course, an adult parent. I hope they're an adult. It was a parent and an adult child who was, I believe, in their 20s, who did not currently live together. So that doesn't really look like a typical domestic assault case or what we would think of as a typical domestic assault case, but it fits under the statute and is generally going to be charged that way. The other really helpful thing about this statute is that other than in number 6, where they're talking about a man and a woman if the woman is pregnant and the man is alleged to be the father, and just be clear, that's alleged to be the father. The man doesn't actually have to be the father. Other than that subdivision, it's very genderless. Same-sex domestic assault definitely falls into family or household member. So we really are catching, hopefully, all of the intimate partner violence that for the folks that we're working with into the statute. Now, I'm going to go back to the statute again quickly, and we have intent. So you can't just you can't just make somebody afraid or make somebody hurt. You have to actually mean to do that. And you don't necessarily have to mean the level of the harm that happens, but you do have to mean to do the thing. So there's that, and I sounds like a strange thing to say, but the definition is literally that the actor either has a purpose to do the thing or cause the result specified or believes that the act will cause that result. So this is the statutory definition of with intent to and intentionally. And I put all of this language in here not because I think you need to know exactly what it means. You're not a lawyer, and you don't need to be. You have us to call anytime you have a question. But what you do need to know is that there has to be some level intent involved in this. So that's important because when a criminal case is charged, the prosecutor has to prove all of the elements of that crime beyond a reasonable doubt. So in the case of misdemeanor domestic assault, they have to prove that somebody did something against a family or household member with this particular intent, and they caused fear or harm. So they have to actually prove each of those elements specifically, or they have not proven that the person is guilty of misdemeanor domestic assault. So you can't have someone who accidentally hurt somebody. That's not going to be something that can be proven beyond a reasonable doubt. Now, you're going to have folks that argue they accidentally hurt somebody. That happens all the time. That's going to be a defense argument that the prosecution has to try to overcome. But the prosecution has to start from a place where they actually have the facts to be able to overcome that intent question. Okay, so bodily harm. I'm sorry, I'm flipping back and forth a lot. So the last definition, and looks like I didn't highlight this, is about bodily harm. And bodily harm sounds very dramatic. It's not. Bodily harm is defined as physical pain or injury, illness, or any impairment of physical condition. And that's defined in statute. The statute is right down there at subdivision 7 of 609.02. So you can look that up if you want to. Good examples that I was thinking of, that includes bruises, cuts, scrapes, welts, bleeding, sprains. And it's important to note that bodily harm is less serious than substantial bodily harm or great bodily harm. And those are other terms defined in statute. Those are more extensive, and those are not going to be charged as misdemeanors. So if you have somebody who has a broken bone, some sort of permanent disfigurement, sometimes chipped teeth can be part of that. If you have somebody who has that sort of injury, and the underlying offense is charged as a misdemeanor domestic assault, it's important to work with that victim, actually, that's another assumption I'm making throughout this. I'm assuming you're talking to a victim who is interested in participating with prosecution. That's just sort of the underlying assumption in terms of how I'm thinking about your different advocacy roles within that case. So assuming you have someone who's interested in participating in this prosecution, if they have injuries that go beyond bodily harm, if you're thinking, man, this seems more like substantial bodily harm or great bodily harm, prosecutor needs to know that. Okay, Ty, do we have any questions yet?
No, we do not.
Okay, so I'm going to move on unless anybody has any questions about the definition to start with.
Yep, so far there is no questions.
Okay, great, thank you. So this is kind of an overview of what we're going to talk about. Obviously, there's an incident.
Lindsay, I'm going to stop you because you haven't started on the new section yet. A question did just come in.
Oh, perfect.
And
what is the question?
The question is, what would choking or strangulation be?
So strangulation and choking is actually a completely different statute. And it's not a misdemeanor. And it's not a misdemeanor because there's actually a lot of work been done around strangulation, and the understanding that is an offense that is more likely to lead to death and a homicide than other kinds of domestic assault offenses. So it is completely separate. It is not in, it's a totally different statute, just like a terroristic threats is a different statute, or I don't know, what's another, I mean, there's a variety of different statutes that domestic assault behavior falls into, and that one is completely separate from this, and it's more serious. Does that answer your question? Are there any other questions?
There's not another question after that one, but
okay.
If the answer that Lindsay gave is not didn't answer your question, feel free to note that, and then I'll follow up at the end of the webinar. Okay.
Thank you.
Mm-hmm.
Okay, so this slide is essentially an overview, but I want you to know a little bit about where we're going. Obviously, there's some sort of incident. There's a domestic assault incident that happens. There's an investigation by law enforcement. The culmination of that investigation is either an arrest or a ticket, if we're talking about a charged case. Then there's a first appearance, and you're going to hear first appearance. There's a couple different ways there's a couple different names for it. It's also called an arraignment or a Rule 5 hearing. Rule 5 comes from the Rules of Criminal Procedure, and there's the first hearing in the Rules of Criminal Procedure, or the arraignment hearing, is a Rule 5. The second is a Rule 8. So sometimes you'll hear that language. And then sometimes there's a second hearing. Second hearing would, in a misdemeanor case, a second hearing could be a contested omnibus hearing, a plea hearing, or a settlement conference. And we'll talk specifically about what that is and when we might have one of those kinds of hearings. And then you'll go from there to a trial. Assuming the case isn't resolved, you go from there to a trial. And the trial can be either a jury trial or a court trial or a bench trial. And a court trial and a bench trial are the same thing. That is when the judge makes the decision, not the jury. So there's no jury involved. Then you'll have sentencing, and generally in misdemeanor domestic assault cases, you're looking at probation rather than a significant jail sentence. Okay, so there's this initial incident and initial law enforcement involvement, and here's my first LE that I noticed that I did throughout. Incidents often occur in private. So generally, you're going to have the victim calling 911. Sometimes you're going to have the abuser or a neighbor even calling 911. Sometimes they're occurring in public. You might have a bystander or an intervener who's calling law enforcement, and that 911 call is in most, if not every jurisdiction, is going to be recorded, and it's going to become part of the case. If the victim is calling 911, it's generally going to be admitted into evidence at trial as something called an excited utterance. And the only reason that's important for you is that sometimes that 911 call can be utilized without the victim having to testify. And we'll talk later about why generally the prosecutor is going to need the victim to testify in order to move forward with prosecution. But the 911 call is a little bit of an exception in that it can often be admitted into evidence as something called an excited utterance, which is an exception to the hearsay, and separate from some of the other rules that would often require a victim to testify. Someone else calls 911, then that person is often going to be called as a witness in order to testify to what they saw or heard, whatever made them choose to call 911. Again, the prosecutor may still use the audio of that 911 call, but they're generally going to want that person to testify also. So law enforcement arrives as a result of some sort of 911 call. There's an investigation. They interview the witnesses, including the victim, and I'm sure you know as well as I do that sometimes the victim is the only witness. Sometimes there's no one else to interview. So they do all the interviews. They document the scene. They document people. They're looking at people's demeanor, or should be looking at people's demeanor. They're looking at injuries. They're looking at whether or not there's, maybe if it's in a home, whether or not there's something overturned in a way that fits with with the victim's story or the abuser's story. So they're doing all of that investigation, and I should note that law enforcement agencies are required under Minnesota statute to have a written policy about domestic violence arrests, and that a report is required even if there's not an arrest. Now, that doesn't mean an extensive report is required. There's some minimal requirements in the statute, but there does have to be some sort of report done, even if an officer chooses not to arrest after coming out to a potential domestic assault scene. So if there's probable cause for a domestic assault, law enforcement may make that arrest. And the first bullet here, that the incident need not be in presence of officer, is important because many misdemeanors in Minnesota, if not most misdemeanors in Minnesota, those incidents often need to occur in the presence of an officer in order for an officer to actually arrest instead of simply issuing a ticket. Domestic assault is different than that. It does not need to occur in the presence of an officer. That arrest can occur anywhere, and it can occur up to 72 hours after the incident. So if we've got somebody who is gone on arrival, 911 call, victim calls 911, abuser leaves, law enforcement arrives, law enforcement has up to 72 hours to execute that arrest as long as they have probable cause that domestic assault occurred. So as long as they do their investigation, they interview the victim, and they decide that they have probable cause to make an arrest, they have 72 hours to actually make that arrest. They also have an option to, let me back up a second. 72 hours, that's the max. After 72 hours, they can no longer make that arrest. But they do have an option to mail a ticket or a citation, because sometimes law enforcement simply can't find the abuser. One of the downfalls, one of the many downfalls to mailing a citation is, at least in the county that I worked in, if our law enforcement mailed a citation, that first appearance was generally out of custody. So the first time that defendant saw a judge, it would generally happen out of custody and not necessarily on a specific date. Our tickets said things like appear by such and such a date, and they could appear, any Tuesday or Wednesday afternoon at 1 o'clock, and they'd be given sort of these parameters, but it wouldn't be a specific date. And you'll see in a minute why that's important. It just makes it more difficult to track, and a little bit, it makes it harder for the victim. It makes it harder for the prosecutor, because they don't know exactly when somebody's going to come in. So another question about the arrest is how long can somebody actually be held? So in terms of advocacy tips, presumably your program is getting some sort of call, or you're getting some sort of notification when an arrest occurs. So when you do your outreach to the victim, it's really important for you to know what your local process is around how long and how folks are held in custody. Now there's two main rules that govern this, and you'll hear something called Riverside. You'll often hear the phrase Riverside judge, and what that means is that, well, let me back up 1 minute. This is most important when somebody is arrested on a Friday or over the weekend. If someone is arrested Monday through Thursday, they're generally going to be, if they're being arrested, they're generally going to be held overnight and arraigned in the morning. So when but we know that lots and lots of domestic assaults happen over the weekend. So if we have someone who's arrested on a Friday or a Saturday night, then that calculus changes a little bit. So you'll hear a phrase called Riverside judge. And what that means is that there's a requirement that a probable cause determination needs to be made by a judge within 48 hours of that warrantless arrest. So say we've got somebody who's arrested at 10 o'clock on a Friday night. They're charged with misdemeanor domestic assault, and they are arrested and ticketed by law enforcement. They're taken into custody. So there must be a probable cause determination by a judge within 48 hours of that warrantless arrest, and Monday is too late. Monday is going to be outside of the 48 hours. So that means a judge is actually going to have to make that probable cause determination over the weekend. And generally that happens in the county I worked in. We had a Riverside judge who was on call, and they would go in on a Saturday late morning because that was late enough to catch anybody to review anybody who couldn't wait until Monday morning. And they would come in and they would review all of the paperwork and make those probable cause determinations. There's the other guideline, or the other rule, is that there can't be more than 36 hours between a warrantless arrest and an arraignment. Now that at first sounds very quick. However, that rule excludes the day of arrest, Sundays, and legal holidays. So again, if you have this person who is arrested at 10 o'clock on a Friday, Friday doesn't count, Saturday counts, so you have 24 hours there, Sunday doesn't count, so arraigning them Monday morning is no problem. So generally that's how you end up with a Friday or Saturday arrest and a Monday arraignment. However, it's really important for you to know how your local jurisdiction handles these, and whether or not they have a Riverside judge coming in and holding folks, or whether or not they're cutting people loose from the jail over the weekend, or how that process is working. Okay, so there's an arrest. Now we're looking at actually being in court. In court, we have a cast of characters in court. We obviously have the judge. We have the prosecutor. The prosecutor does not represent the victim. The prosecutor represents the state. The prosecutor has a whole variety of guidelines that they need to follow around how they work with victims. 611A Victims' Rights Statute gives them a lot of parameters around how they're supposed to be working with victims, or how people are supposed to be working with victims, but they represent the state. Hopefully, in more cases than not, the state's interests and the victim's interests are aligned. But as you and I know, that's not always the case. And it's important for you to understand that, because it's important for victims to understand that the prosecutor doesn't necessarily represent them and exactly what they want to see happen in a case. It doesn't mean that I always used to tell victims that it doesn't mean I don't listen and really take into account what you want to see happen on this case, but the final decision is really the prosecutor's decision. Now, there's also a defense attorney, and the defense attorney can be a private attorney or private counsel, it's sometimes called, or they can be a public defender. And defendants in court fairly regularly say terrible things about public defenders, or I've heard people say terrible things about public defenders, and asking for a real lawyer and those kinds of things. And some of the public defenders that I worked with, some of them were some of the best attorneys that I've worked with. They know this. They're in court every day, and they're very good. So there's no distinction between a private attorney and a public defender other than who pays them. And everyone is entitled to apply for a public defender, and then a judge is going to order whether or not they get one, and it's based on income. Now, the public defender's office generally staffs arraignment court, or that first appearance court. So there's going to be a public defender there whenever people are being arraigned in custody in the vast majority of jurisdictions. But that does not mean that is the public defender who's going to be assigned to a case. So if a defendant comes in, is arraigned, applies for a public defender, they're talking to the person who's there, then that file then goes back to the public defender's office and is assigned to an attorney who will take it through the end of the case. And I put a note in here, bring paper and pen, and sticky notes are always helpful, and we'll talk about that in just a second. It is crucial, those items are crucial or very helpful, because one of your roles is to help that victim communicate their wishes to the prosecutor. So what happens, first we'll go through what happens at a first appearance, which is also called an arraignment or Rule 5. The judge will inform the defendant of the charges against them and their rights. Sometimes they read the charges in full. The defendant may enter a plea. Their plea is going to be, unless they are suddenly resolving the case at the first appearance, their plea is going to be not guilty. And the judge is going to issue conditions of release generally. And what will happen prior to the judge issuing conditions of release is the prosecutor and the defense attorney, who's generally the public defender who is handling that courtroom for the morning or for the day, will make arguments to the judge about what conditions of release are appropriate. So some of the possible conditions would be cash bail or bond. And the difference between bail and bond is bail is cash, or check, I assume. Bond is when someone actually hires a bondsman to bond them out. So they're only paying a portion of that bond to the bondsman, and then the court holds the entirety of the bond. There can be alcohol restrictions. There can be a no contact order as part, and that there can be a no contact order as part of the conditions of release. There can also be a domestic abuse no contact order. You can have both of those because they're two separate things. A domestic abuse no contact order, a violation of that is actually criminally charged as a new offense, while a violation of a no contact order as a condition of release becomes a violation of a condition of release, not a new crime. So that's an important distinction. You can have a trespass order. There's a new statute that allows for a geographic restriction, which means that you can have somebody you can restrict somebody from a particular area. Say you can restrict somebody from a particular neighborhood, for example. I know there's one case, and we were talking about geographic restriction at New Laws last fall that Raina was talking about, where literally the only reason this person was in a particular town was to commit criminal offenses against their victim. And the geographic restriction statute, if it had been in place at that point, could have restricted that person arguably from the whole town. And then there's restrictions around firearms. And so now this is where my comment before about bringing a paper, pen, and sticky notes comes into play, because a huge role for you, both in explaining to the victim about what's going on, is separate from explaining to the victim what's going on, is helping that victim communicate their wishes to the prosecutor, because they know what's going to keep them safe. The prosecutor only knows what's in the police report. So they literally know what's in the police report. They know what's in front of them. They may have a prior report, or they may have information about somebody's prior offenses, but about the incident, they really only know what's been written down in the police report. And it's generally happened pretty quickly, and it's generally not all of the information. So if you are working with a victim and they have specific wishes about what they believe is going to keep them safe, the prosecutor is going to want to know that. Okay, so Ty tells me that we have another question.
Yes, we do. There's actually a couple of questions.
Okay.
The first question is, sometimes our law enforcement tells the victim on the scene of a domestic that if they aren't willing to sign something, that law enforcement's not going to make an arrest. So doesn't this fly in the face of the statute? They say they're not going to make an arrest if the victim isn't going to cooperate because they don't want to be accused of making a false arrest.
Well, I'm sorry your law enforcement is doing that, and I would love to have a conversation about this sort of offline. Maybe you can shoot me an email, because the victims should not be asked to sign something at the scene in order for a case to move forward. Now, they may be asked to give a statement, and provide a statement. Generally, those aren't signed. Generally, that's going to be, it's going to be recorded by law enforcement, audio and now sometimes video with body cam, but it's generally not going to be a signature necessarily. So I don't know exactly what law enforcement would be asking them to sign at the scene. It is accurate to say that in many, many cases, misdemeanor domestic assault cases are difficult, if not impossible, to prosecute to a conviction without a victim participating in the prosecution. And we'll talk about why that is a little bit later, but that isn't a determination that should be happening in the way that you're describing. Was there another question, Ty?
Yeah, there's one more.
Okay, thanks.
So we have been seeing cases going from a first appearance to an arraignment hearing as opposed to an omnibus hearing. Is there a reason that one would have an arraignment hearing scheduled after the first appearance, while others were having an omnibus hearing?
Oh, that's interesting. You know, the county that I worked in, we had unless somebody filed an omnibus motion, we had a first appearance or arraignment hearing, and then we went straight to trial. And you didn't actually, the defendant didn't actually go into court in between their first appearance and their trial date. So I think I have just a second here. Well, maybe I don't have it. I was thinking I had it on a slide. In terms of, so a first appearance, you can have, in between a first appearance and a trial, you can have a variety of different hearings. Some counties will do an automatic default omnibus hearing, which really operates as like a settlement conference or a potential plea hearing, and that's going to be basically a local choice that your local judges are making and your local court is making. When I initially started prosecuting, all of our misdemeanor domestic assaults started at a first appearance. They went to which could also be called an arraignment or Rule 5. They went to a default omnibus, which could also be called a settlement conference, and then they went to trial. A few years after I started, our local jurisdiction got rid of those default omnibus hearings entirely. They are not required under the rules. So the only time we had default omnibus hearings we didn't have default omnibus hearings. The only time we had omnibus hearings was when an omnibus motion was filed. And I'll talk about what an omnibus hearing is in just a minute, but that would actually take a defense attorney filing or a defendant filing a motion and requesting that hearing. And I think did I get the entirety of that question, Ty, or was there a second part to that question?
That was the question.
Okay. We'll talk about omnibus hearings in a couple minutes.
So there's a couple more questions, Lindsay, and what
sure.
I'll do is I'll read the question to you, and then you can just decide if you have time to answer them or not. So the next question is, if a defendant does not qualify for a public defender, are they still allowed to be represented by one at the first appearance? So the judge will say that the defendant doesn't qualify and the public defender doesn't remove themselves as counsel in that initial hearing.
Yeah, and you know what? I have that on a later slide, but I'll answer it right now, and then we'll just skate through it later. Yes. So what often happens is that the public defender's office has an attorney who is staffing that first arraignment courtroom, that first appearance or arraignment courtroom, and that public defender is often going to be speaking with everybody who's there for an in-custody arrest. Anybody who's there for an in-custody arraignment, or they will be speaking to anybody who has applied for the public defender, regardless of whether or not that paperwork has been processed, because usually it hasn't even been processed. And they will help them through that first appearance. Now, it's not unusual, and again, in the county that I worked in, it was very, very common to have a defendant who is in custody. They're there for their first appearance or their arraignment. There's a public defender there. They've applied for the public defender. The public defender is helping them through, representing them through that first appearance. And during that first appearance, the judge reviews their application and says, you don't qualify for the public defender. They'll help you through the rest of this hearing, but you're on your own after that. So that's not uncommon at all. Was there a second question, Ty?
Yes. Well, there's a new question that just popped up. So we're confused as to why they're having an arraignment hearing following a first appearance, because aren't they the same thing? Why would there be two?
Sorry.
There's two questions. Why would there be two?
You know what? It's probably just an odd labeling. It's probably a continued first appearance for some reason, and they're just choosing to call it an arraignment, or instead of calling it an arraignment the first time, they called it first appearance, and then an arraignment the second time. It sounds like it's generally just a continued first appearance. Okay, so let's keep going on a little bit, and then we'll get to some more questions later. So you're at your first appearance. They're at the first appearance. Potentially the victim is there, and you're having conversations with the victim, and the victim says, "What about all this other stuff?" Say this is again our Friday arrest, and it's a Monday arraignment. So we've had just over 2 days for bruises to show up. What if you're talking to a victim and they say, "Look, I've got all these. Look at all my injuries. They were photographed, but those photographs didn't really show anything because it had just happened." Well, this is where your relationships come in. I'm just going to really encourage you to work really hard on your relationships with your local prosecutors, and then your local law enforcement, and to really open up those lines of communication, because those kinds of things get missed otherwise. I know of one county, and I'm not even going to say which one it is because I think I remember which one it was, who has officers who follow up on misdemeanor domestic assaults within the first week so that they can do some of this additional investigation and take photographs of injuries, of bruises that show up later, of injuries that somebody didn't even realize, something that they didn't even realize hurt because there was something else that was demanding their attention in a larger way. I know of one county that is doing that, but lots and lots and lots of counties, law enforcement will do that initial investigation. They will write their ticket. They will send the report to the prosecutor, and then they're done unless there's somebody else gets them involved. So if there's additional injuries or injuries that can now be photographed, that's something that you can work with both your law enforcement and your prosecutor's office to figure out the right path for that victim to go in order to get that information documented. There's a lot of other information that you're going to use those relationships to communicate in the same way. Maybe there's an additional witness. Maybe law enforcement didn't realize that the neighbor could hear the whole thing and the victim knows that. Well, that's important information. Maybe there's digital evidence. This is a sexual assault case, but my best recent example is a sexual assault case that I was talking to the prosecutor, and they were meeting with the victim, and I said, well, make sure you find out if there was any communication after the incident, because there may be digital evidence that you can use. Well, the prosecutor talked to the victim, and the victim said, oh yeah, he texted me and he said he was sorry. We wouldn't have known, the prosecutor wouldn't have known that without asking the question, and the victim didn't know to provide that information. She didn't know it was important information for the prosecutor to have. So if there's digital evidence, and often it's going to be a text or something electronic saying, I'm sorry, or some sort of admission, that's important. And again, this is from the perspective of the victim who wants to participate with prosecution. Maybe the victim forgot to tell law enforcement something. This is obviously an incredibly stressful situation, and they've just gone through a very difficult situation, and maybe they forgot about something. Maybe you have a copy of the police report, and the two of you are looking at it, and you realize there's an error that needs to be corrected. Maybe you're talking to the victim and they are saying, look, there's these prior incidents. He's done this in exactly the same way these other times. That's important information for the prosecution. And I include restitution in here because if it's not notated in the police report that something was damaged and a victim needs restitution for something, then the prosecutor doesn't know, and they don't know to ask for it to be they just don't know to ask for it. So that's another important consideration. Okay, so we're talking about arrest. We've got somebody in custody. The first thing I'm going to talk about just really briefly is jail versus prison, because I, to be perfectly frank, didn't realize this until I went to law school. I was an advocate before I went to law school. So jail is local. Jail is going to be under a year. Under a year. So jail is you're going to have somebody in jail serving local time on misdemeanors and gross misdemeanors. And a felony is what can cause someone to have enough executed jail time to be sent to prison. So prison is state, jail is local, and your jails are generally run by your counties. So when you've got somebody in custody and you're working with a victim, it's important to know what their contact provisions are and those conditions of release. What happened at that first arraignment? Is there a DANCO? Is there a no contact order? But then it's also important to know things like, does your jail automatically block a victim's number? The jail that the county that I worked in, our jail automatically blocked the victim's number that they had in the police report, but we could give them an additional numbers to block if we knew of additional numbers that should be blocked. So that's another way that you can work within the system to work with the victim. Unauthorized contact that happens when somebody is in custody. If there's a DANCO or an order for protection, and you've got a defendant who's calling the victim, that is an incredibly easy case. That's a new criminal charge, and it is an incredibly easy case for the prosecution to prove. Almost if not all jail calls across the state are going to be recorded. So it is literally a recorded violation. So it's important for victims to know that, so they can make choices about what they want to make sure, what they're reporting. And I don't know why I wrote relationships here. I think I just wrote relationships here because, again, this is important for you to have these local relationships to know exactly how your jail is operating. Police reports. Victims are entitled to a copy of the police report. There's some distinctions between whether or not they're entitled to the entire police report when the case is still pending, or whether or not they have to wait until the case is closed. There's a few distinctions there, but in general, victims are entitled to a copy of the police report. The office that I worked in, when we actually had a victim witness coordinator, which was incredibly helpful. But prior to that, we didn't. We did all of our own victim contacts. So if I was working with a victim on a case and they asked me for a copy of the police report, I sent it to them, and we did it directly through my office, so they didn't have to go through records, and they didn't have to go through that whole process. Now, your jurisdiction's process may be different. They may want them to go through law enforcement. They may be able to go through you. But again, that's important for you to work with your local folks to figure out exactly what the easiest way for victims to obtain a copy of the police report. At the very end there's a resources slide, and I have I think it's a two-page, a two-page link, or a link to a two-page document that lays this out and is really helpful if you have a jurisdiction that is being where it's difficult for some reason. I'm happy to have further conversations because I know we have counties all over the state where folks are having a harder time getting police reports. Okay, victim rights statute. I hope you all know that there's a victim rights statute. It's 611A. It's extensive, and in some ways, it's incredibly helpful. The most well-known portions of it, I would say, are the victim impact statement and restitution. Victim impact statement, victim is able to make a statement at sentencing about the impact on their life. Restitution, they are able to request financial restitution for, maybe it's medical expenses, maybe it's something that was broken. Enforcement of the victim rights statute is a little harder because there is none. There is no enforcement mechanism in that statute at all. So again, it's a tool for you, but this is going to be about relationships. How does your local office, prosecutor's office, handle victims' rights? Do you have a point of contact there? Who do they want you calling? What's easiest for you and for them, so that the information can get passed along? Did their prosecutors handle the victim contact on their own? We did that for years. until we get a victim witness coordinator who became that point of contact. So again, working with that local prosecutor's office, they should want to be in compliance with that statute, and sometimes it's really useful if you've got somebody who is being a little bit difficult in some way, if you can point to the statute and say, hey, you're actually supposed to be doing it this way. How can we figure this out? That can be a really useful tool. Okay, so here's this possible second hearing that we were talking about. You could have a continued arraignment. You can have a settlement conference. You can have a contested omnibus. A contested omnibus hearing is when constitutional issues are litigated. The two main issues that I've seen on misdemeanor domestic assault cases at the contested omnibus stage tend to be around search and seizure. So search of a place or a person, seizure, or identification of a defendant. Identification is substantially less of an issue generally for domestic assault cases because you generally have people who know each other, so it's not a stranger crime. But search and seizure is one that you definitely will see some hearings about. At that second hearing, again, facilitate communication with the prosecution. Does the victim need to be present? Well, if it's a continued arraignment, settlement conference, probably not. You may be able to just relay the information to them. If it's a contested omnibus, maybe the victim has to testify, and you're going to want to work with the prosecution so that they understand what portion they have to testify about, a portion of the incident. So you're really there as a support person and to facilitate that communication with the prosecutor. Do we have more questions, Ty?
We do. We have one question. Okay. Is the bail evaluator going to contact the victim after an arrest?
Oh, that's a good question. I should have included something about that. Probably not. So I hate that I keep saying this, but it's really true. It's going to be different in every county. So some counties have extensive bail evaluation tools that are pretty well done and expansive. Other counties really don't. So it's totally going to depend on the county, and I would be very doubtful if bail evaluators are contacting victims in many misdemeanor domestic assault cases. Maybe on more serious and gross misdemeanors and felonies, maybe, but I would be a little bit surprised if they were on misdemeanors. In my experience, the county that I worked in, none of that just didn't happen. We often didn't have bail evaluations completed. And we often actually didn't have any financial bail on domestic assault cases, misdemeanor domestic assault cases at all. Was there another question, Ty?
No, that's the last one.
Oh, okay.
So far.
Okay. One thing I should talk about on that same topic really quickly, and I think I'm a little worried we're going to run out of time, but really, really quickly on the topic of bail, monetary bail is not always, there's pros and cons to it on misdemeanor cases because someone can be ordered to pay a certain amount of monetary bail and turn around and it can trigger a request for a speedy trial. And sometimes that is not the best. Sometimes it's hard if our goal is a conviction. Sometimes it's hard for the prosecution to have everything lined up in order to try the case fast enough for it to make it within that speedy trial window, because a misdemeanor speedy trial it's a very, very quick turnaround. It's like a week. So it's very, very quick. So there's pros and cons to that. And the speedy trial, I'm sorry, it's not because it's a misdemeanor, it's because somebody's in custody. So if you have somebody in custody who makes a speedy trial demand, it's going to be a very, very quick turnaround. So there's pros and cons to that. Okay, for trials. So there's a jury, we can have a jury trial or a court trial. The jury, for a jury trial, the judge is making the legal calls, and the jury is making the fact calls. So the jury is figuring out who is, who they believe and who they don't believe. In many ways, in many situations, and they're making the decision about whether or not somebody is guilty or whether or not the prosecution has not proven their guilt. In a court trial, the judge is doing all of that. Sometimes it's called a court trial, sometimes it's called a bench trial. But the judge is making all of those decisions, both legal and factual, in a court trial. So your jury trial calendars, again, this is going to be a local practice. The county that I was in, we had domestic assault only calendars, domestic violence only calendars. So they weren't all misdemeanor domestic assault, but they were all domestic violence related offenses. And I think my worst calendar, I had 28 misdemeanor domestic assaults, and I think a handful of order for protection violations on that calendar. That's with probably 20 different victims. So those are incredibly difficult to handle from a prosecution standpoint, and they're incredibly difficult from a victim standpoint. And your county is going to do that. Your county, it's a local decision as to exactly how your county does that. So you may want to know how many cases tend to be on these calendars. Are they domestic violence only calendars, or are they all, are they tossed in with all of the other misdemeanors? Are there going to be thefts on this calendar? How long is the calendar? Is it a week-long calendar? Are we asking a victim to be available at some point for a whole week? Because the case doesn't generally last a week. Generally, misdemeanor domestic assault case is going to be tried. If it's a jury trial, it's generally going to be a day-and-a-half trial, is what I always generally estimated. So how long is that calendar? Are there plea offers out there? There's rules within the victim rights statute around victims having information about plea offers, and the better the communication is between you and the prosecution and the victim, the more smoothly that's going to go. Continuances. Sometimes the prosecutor knows there's no way they can try it on the week that it's scheduled because the officer who responded is gone and they're making a continuance request. Well, that's information that they may be willing to share with you depending, and it may be important to the victim. So we talked about the difference between jury trials and court trials, and I feel like I'm flying now because we only have about 20 minutes left. That is one of the significant decisions that the defense gets to make, is whether the defendant testifies and whether or not they want a jury trial or a court trial. So the state does not, the prosecutor, the state, the victim, none of those people don't get to decide, yes, I want a jury trial. The defendant gets to decide whether or not they want a jury trial or a court trial. And then they decide whether they testify. One of the things that often happens prior to trial is motions. Motions will be argued maybe about what evidence is coming in, what evidence is not allowed in. And those hopefully happen prior to trial. Sometimes they happen during trial, but they hopefully happen prior to trial. They can happen just prior, or they can happen on a date that's specifically scheduled for motion hearings. Okay, there we go. Okay, so the order of a trial, you're going to have opening statements. The state goes first, the defense goes second, but often the defense will wait and they will not do their opening statement until after the prosecution's case is complete. That's a really common way of doing it. So the state does their opening, then the state has their case in chief, which means the state calls all of their witnesses. And for each witness, and I just wrote this on here once, but this happens for each witness. So if it's a state's witness, the prosecutor does their direct examination, and then the defense has a chance to cross-examine that same witness, and then the prosecutor has a chance to redirect, and then the defense has a chance to recross, and it can go on like that for quite some time. The thing that it's not necessarily important for you to know, but it's interesting for you to know, is that the information cannot get more expansive. So the defense cannot recross the witness on something that wasn't already brought up prior to that. So the goal really is to continue narrowing down that information. And that happens with each witness. Obviously, if it's a defense witness, then the defense goes first. Defense case usually begins with the defense opening statement. The defendant gets to make the decision whether to testify, and then the case ends with closing arguments. The state goes first, the defense goes second, and then the state does have a chance for redirect. So when you are in the middle of trial, or when you're working with a victim whose case is going to trial, there's a variety of things for you to think about. And again, a lot of these are going to be things that you can really work on locally. Is there space for victims in the courthouse? I was in one courtroom in Dodge County that is fabulous. It's a little tiny courtroom, and they have space on the side for the victim to sit in a separate room with a window with shades that can be open or closed, and they can watch what's going on a screen. And then obviously the audio is piped in somehow also. So they've got this great electronic solution to how to keep a victim informed without them having to sit in a small courtroom with their abuser. Now, if the victim's going to have to testify, can they be in the courtroom during testimony? Often not. That's something that the prosecutor is going to want to prep that victim, and you're going to want to ask them and help the victim ask them whether or not they can be in the courtroom during different portions of that testimony. Maybe you know of a particular security issue. The county that I worked in, we regularly had trials without a bailiff in the courtroom. We didn't have security in the courtroom if somebody was not in custody. But if I knew of a security issue, if I was particularly concerned about a case, I could ask for law enforcement to be present. But I wouldn't necessarily know to ask if somebody didn't let me know there was a specific security issue related to the case. I was usually getting that information from either a victim or an advocate. Okay, so victim testimony. There's a case called Washington v. Crawford that really impacted the landscape in terms of victim testimony. There's no reason for you to look up this case or read this case. Just know that one of the key things that this case means is that prosecutor will generally need the victim to testify. It sets guidelines and rules around what kind of evidence can come in and how, and when a victim is available, which tends to mean alive, they are generally going to be needed to testify. Now, the prosecutor is generally going to want to prep the victim. You depending on your relationship with the prosecutor, I generally wanted my advocates involved in some of that prep, but you're also a support person and working to facilitate the communication as well. Okay, so actually, let's go back. Do we have any questions, Ty?
No.
Okay, I feel like I just flew through that.
Nope, no questions.
Okay, so hopefully we got a conviction. That's the goal, right? So say we have a conviction. When will it occur is my first question, because if you have a plea hearing, you know when it's going to happen, but a guilty plea can occur at just about any of these hearings that we're talking about. So somebody can come in for their first appearance and plead guilty. Someone can come in Someone can file a contested omnibus motion, have their contested hearing, maybe lose their issue, and then plead guilty. So there just has to be really good communication to make sure that the victim is aware when, if a guilty plea happens, when the sentencing is actually going to happen. Because on misdemeanor cases, oftentimes the sentencing will happen immediately after a guilty plea. And it's important to make sure that the victim knows when that's happening so that they can be there. And the best case scenario is that a pre-sentence investigation occurs. I know that does not happen in a number of places on misdemeanors, but that's the best case scenario. Pre-sentence investigation is generally going to be done by probation, and they're going to be reaching out to the victim to get information, and they're going to it results in better sentences, or more, maybe not better, but more informed sentences. But it simply, to my knowledge, does not happen on a lot of misdemeanor domestic assault cases, and I've always been told it's a resources issue. So as I'm sure you know, a victim can make a victim impact statement at that sentencing hearing. Okay. Excuse me. It can be written or oral. It can be done, it can be written, it can be submitted to the judge in writing, or it can be read in open court. And it can be read in open court by you, the advocate, the victim, or the prosecutor. Those are the main three people that read it. I have seen victim impact statements read by like a family member, usually after getting permission from the judge. But generally it's going to be the victim, the advocate, or the prosecutor. Or the victim can simply stand up and make their statement orally, or sit, actually. Generally they're standing because that's how the court is addressed. But I've seen judges say, why don't you just sit there and make your statement orally? Restitution. Restitution is important for the prosecution to know about prior to sentencing, because if restitution is not reserved at sentencing, you can lose your ability to do it later. So it can be reserved without the exact amount. Say you have a victim of a misdemeanor domestic assault who has significant medical bills. I know that this is that misdemeanors are something less than things like broken bones, but that doesn't mean that there aren't significant medical bills that can go along with that. Say the bills are still coming in. Well, the prosecutor can go in and say, there is restitution. This is what we know about so far. I'd ask the amount to be reserved, and then provide a timeline for which that information can get submitted to the court. But if that doesn't happen, it's hard to go back and do it later. DANCOs, domestic abuse no contact orders. This is important. DANCOs, a pretrial DANCO does not continue after sentencing. So if you have someone who was ordered, if you have a case where a domestic abuse no contact order was ordered at arraignment, the defendant has pled and been sentenced. If the court does not order a post-conviction DANCO, or order a DANCO at that time of sentencing, then there is no DANCO. So that's important. There can be just like there can be at the arraignment, there can be a condition that just says no contact, or there can be that domestic abuse no contact order. And the difference again is that the domestic abuse no contact order, a violation of that provides for a new criminal charge, the basis for a new criminal charge. Okay, other things that can go into a sentence, various programming. The county that I worked in, we generally had domestic violence inventories ordered, and that was a tool that probation used to determine what kind of programming a defendant was going to be put through. Some counties order very specific programming. It's going to be more specific if there's a pre-sentence investigation. It might be more general if there's not. But there's generally going to be programming ordered, and that can include use provisions, use of alcohol or other substances. It can include specific requirements to not use. It can include chemical dependency evaluations, those kinds of things also. Firearms, we can have orders regarding not disallowing people from carrying firearms. That does not need to be specifically ordered as sentencing, but we can have specific orders related to firearms as sentencing. And let's see, types of sentences. We're going to go on. We've got a couple different kinds of sentences. You can have all of these things can happen with just about any one of these sentences. So I have two slides that are about the types of sentences. And they are essentially from the least restrictive to the most restrictive. Continuance for dismissal is the least restrictive. Now, this should be a very unusual disposition. It shouldn't happen very regularly at all. When I was prosecuting, I definitely used this as a tool, but it was not a common situation for me to offer a continuance for dismissal. What it means is the criminal case is continued and will be dismissed at some later date. So it just sort of sits there, hanging over somebody's head. And as long as they complete a list of required conditions, then it gets dismissed at the end. So that Ty is texting me and telling me we only have a few minutes left, so I'm gonna keep flying through this. So that is a potential sentence disposition, but it should be fairly rare. Stay of adjudication. With the stay of adjudication, the defendant lays a factual basis, so they admit their guilt on the record. The judge says, yep, those facts are sufficient for a conviction. You committed domestic assault, but they stay the entry of that conviction. So they don't actually enter it as a conviction on the record. That stay is usually for 1 to 2 years as the defendant completes required conditions, and then eventually, subsequent to that, it ends up being dismissed. Sometimes this is used as a way to get a defendant into treatment or counseling more quickly. The issues of these two kinds of dispositions is if someone commits a subsequent offense, this can't be used as a prior. Stays of imposition, that's what the county that I worked in used a lot of. The defendant would plead guilty, including that factual basis. The judge would order a probationary sentence, but they wouldn't specify a jail sentence to serve. So a misdemeanor domestic assault, the maximum sentence you can serve on a misdemeanor is 90 days in jail. So that defendant knows that 90 days is the maximum, but the judge doesn't specify whether or not it's going to be 45 days or 60 days or 90 days if they end up with a probation violation. Stay of execution. Again, the defendant pleads guilty, including that factual basis. The judge sentences the defendant to a particular number of days in jail, stays a number of days of that sentence, as long as the defendant follows through with the list of conditions. An example would be ordered to serve 90 days in jail, 60 days reserved or stayed, as long as you follow all the conditions of probation. So they would serve that 30 days and the 60 days would hang over their head. Executed sentence is when they're actually sentenced to a specific number of days in jail and there's no probation and they're simply done. They serve their time and they're done. All of those can be used as priors if there's a subsequent offense. Excuse me, I'm starting to lose my voice, I think. Or at least it's making me cough. So post-sentencing, the victim may communicate with the probation officer. The probation officer is generally only going to provide the victim with information that's allowed through a release of information. So the probation officer, it ends up being sort of not a one-way street, but the victim can definitely provide information to the PO, but the PO can't necessarily tell the victim everything that's going on with the defendant. If you've got a victim whose abuser is in jail, there's executed jail time, you can use Vine. to get so they can get information about when that person is being released, and they can do that anonymously. And that is that's on a later slide, on a resources slide. And when you've got probation violations, probation violations could involve the victim. It could be say contact violation. That's going to be a violation that involves the victim and could require the victim to come in and testify that there was unauthorized contact. So I think we made it almost. I think we've got 2 minutes here left. When in doubt, call us. This is not meant to make you an attorney. This is not. This is simply meant to give you an overview, to provide some information about definitions and what different hearings are, and some of the pitfalls and some of the ways that you can really serve your clients well. But when in doubt, give us a call. Here are the resources, and I think this whole PowerPoint, Ty, can they download this PowerPoint?
Yes, so under the handouts tab, click on that and the PowerPoint should be there, and you can certainly download it, print it out, whatever you need. And this webinar was being recorded, still is being recorded. And once we get that uploaded and ready to go, I will send an email out to all of you. And you can listen to it or have other staff in your office listen to it on our YouTube page.
And you can also subscribe to our YouTube channel. So I think there's a link from our website, or you can look in YouTube and look for Standpoint MN. And you can subscribe to our YouTube channel, and then I think you will, depending on how your notifications are set up, you can get notification of any additional webinars or videos that we put up on that page. Because this webinar will be there, and we've got other webinars already out there and more to come. So here's some resources, and I'll just end with our contact information. Are there any other questions? I know I kind of flew through some of that.
No, there is no other questions, but like Lindsay said, if you do have questions after this, please feel free to email or give us a call.
Thank you. Thanks, Ty.
Yep. Thank you, everybody.